My name is Leonard Mondschein, and I'm with the Elder Law Center of Mondschein and Mondschein, PA in Miami, Florida. And we're going to be talking about special needs trusts today. The whole idea of special needs trusts and what's actually behind them is the purpose is to protect the person's assets while maintaining public benefits. So many times you'll have somebody that is on Medicaid or SSI, and there are different times that they may get a lump sum of money which may interfere with their public benefits. So for instance, they may get an inheritance, they may be involved in a divorce, or in many cases they receive money in a personal injury settlement. And in those cases, if they're on Medicaid and SSI or both, they can lose their public benefits when they receive that money. And so special needs trusts become very important in that area. But there's many different types of special needs trusts, and they're used, in different cases. And so what we're going to do is we're going to talk about the different ones and the characteristics. And it's important because as attorneys and also working in the court system, you're going to have attorneys coming before you with different types of special needs trusts, and they may not necessarily identify that trust with you. They may say, well, I'm here with a special needs trust, and you think you know what that trust is about, and then you find out it's a different type of special needs trust, and maybe you're not familiar with it and you haven't seen it before. And so, you can be confused. You might think that what they did is not correct, or you've never seen it before. So what I'm going to try to do is to give you that sort of broad feeling of the different types of trust, characteristics, maybe how you're going to see it. And this way, you may even discover when the attorney comes to you and you're looking over their pleadings, you may find that they're there with the wrong type of trust, that they don't understand it. And special needs trust is a very specialized area of law, even more specialized than probate itself. You'll find, as you have already, that there are many attorneys who can probate an estate, but you won't find that many that are dealing intimately with special needs trusts, because it's a subspecialty and it's a more complicated area. And it requires a very specific knowledge of public benefits, sometimes VA benefits, SSI, SSDI, Social Security, pensions, also taxation. So attorneys who draft special needs trusts have to really understand when the client comes in to see them what type of trust they're drafting, and not just the type of trust, but how is that trust drafted? What characteristics should you be putting into that trust? What type of language? What problems are you trying to solve? And so you won't see that many attorneys who are doing this type of work, just really a handful. And so what happens is, once in a while, an attorney who's not familiar with this work gets a case and realizes it's a special needs trust, drafts the wrong type of trust. I've seen many special needs trusts that have come to me years later that were basically drafted as what's called third-party special needs trust, but in the trust document it contains what's called a Medicaid payback, which is exactly what you don't want to put into a third-party special needs trust. So, and obviously this was done because the attorney opened up a form book, and you all learned in law school that you're not supposed to become a slave to a form, and this is a perfect example. If you are looking in a form book and it says special needs trust, and you feel, well, I need a special needs trust, but you don't realize that there are different types, you could very easily take a form that is not appropriate. And in the case that I was giving an example just now, if you used what's called a D4A trust, in other words, a first-party special needs trust with a payback provision to Medicaid, where you should have used a third-party special needs trust, you're subjecting your client's assets to Medicaid payback, which would be absolute malpractice and could cost the client sometimes even millions of dollars. So it's very important that the attorney who's drafting the special needs trust understands what he's doing, or if not, he should bring in a co-counsel. So we're going to go through each type of special needs trust the best we can in terms of talking about what they're for and the characteristics. So the first type is what's commonly called a first-party special needs trust, or a D4A trust. And the reason it's called a D4A trust is it comes out of a section of the United States Code, which is, the entire section is 42 United States Code 1396, small p, small d, and then 4, and then a capital A. And this is a section of the United States Code that contains most of your special needs trusts, and they all have lettering. And the first one is the D4A trust for short, so you don't have to say the whole provision first. Now, this is the type of trust that you may see a lot of, because this is the type of trust that's used when a client that's on Medicaid or SSI receives a surprise lump sum of money. It could be an inheritance through probate, or a divorce, or a personal injury settlement. And so basically, if that money goes directly to that beneficiary is going to lose their public benefits in 30 days. And the reason that public benefits are so important, especially Medicaid, is basically Medicaid is a person's health insurance. And usually they didn't have health insurance because either they couldn't afford it, or they couldn't qualify for it, or if they received if they purchased health insurance, it would exclude pre-existing conditions. Now, we all know that under the Affordable Care Act, this is going to impact special needs trust work, because now a person can buy health insurance even covering pre-existing conditions, which means you now have something else to think about as an attorney when you go out and practice in this area, and that is, if you do a special needs trust for somebody, you may be committing malpractice because you're subjecting their assets to a Medicaid payback when they could have, cheaper than doing the special needs trust, they could go out and purchase health insurance now. So you have to really analyze your cases a lot more carefully, but that subject I'll kind of stay away from, at least for the time being. We may go back to it, but just to point that out. So essentially the characteristics, of a first-party special needs trust is the trust must be irrevocable. That's the first characteristic. The trust has to be drafted so that the use of the money is for the sole benefit of the beneficiary of that trust, the disabled individual. It can't be used for anybody else. And that's where we'll see later on how people get into trouble, because a lot of times you have a poor family and one of the members just got $1 million settlement. It goes into a special needs trust, and everybody, including the parents, think it's their money. It's like family money. And once you start using the money for someone other than the disabled party, you violate the sole benefit rule, and then Social Security could throw the trust out, and now you lose your public benefits, and you may now have $1 million, but you've now lost your health insurance. So the sole benefit rule is very important, especially during the administration of a trust. The other characteristic is that the trust has to contain a Medicaid payback provision. And what that means is that when the beneficiary dies, if there's any money left in the trust, whatever Medicaid is paid out during that person's lifetime has to be paid back first before any of the money can be used to let's say, go to the beneficiaries of that trust. So for instance, if the disabled person's siblings are the beneficiaries of the trust, let's say there's 2 other brothers and they're going to get whatever is left when the disabled person dies, Medicaid has to be paid back first. So if, let's say, there was $100,000 left in the trust, but Medicaid has paid out $250,000, the beneficiaries will receive nothing. There's no type of apportionment. Yes, go ahead.
Medicaid paid back from the start of when the money was received in a special needs trust.
Correct.
Okay.
Correct. Because there's a Medicaid rule, and this may be what's, I'm trying to read your mind, which is, always a terrible thing to do, because you usually get it wrong, but there's a Medicaid rule about that Medicaid payback is for sums that Medicaid pays after you're 55.
Right.
And that's what I'm reading in what you're thinking. And that's absolutely true, except in the case of a special needs trust, because when you draft the trust, you're putting right in the trust that the money that goes into that trust is going to pay back Medicaid first. So it's even worse than what you're thinking, because if the person was receiving Medicaid prior to drafting the trust, and then you get a settlement, you put in $100,000 in that trust, you got to pay back. So if, let's say, you have a client who's, that Medicaid has paid $300,000 already, and then they happen to get a PI settlement, okay? You have to decide whether you wanted to put that money in the trust or not, because if you put the money in the trust, if you know that your client is going to spend that money, the beneficiary, during their lifetime, then go ahead and put it in the trust because you'll be fine. But if you think that money may sit there because everything else is provided, you may not want to put it in the trust. Now that will obviously cut off public benefits, but on the other hand, if you've got enough money now to buy health insurance, you may be better off, and then you could actually transfer that money, which would be subject to a 5-year look back for Medicaid, but since you're trying to get away from Medicaid, you don't really care. And then afterwards, the money's gone rather than subjecting it to a payback. So there's a certain amount of thinking and planning that has to go into this, as I said earlier, before you actually decide whether doing a D4A trust is the smartest thing to do. And especially with the Affordable Care Act now, you've got that issue of no more pre-existing conditions to think about. And that creates kind of just more confusion to figure out which way you should go. Also, remember that a special needs trust, a D4A trust, is only one option. For instance, if let's say the beneficiary was renting an apartment and now he has $1 million settlement or a $500,000 settlement, you may want to take that money and buy homestead property with it, because homestead property will be an exempt asset and now the person has a home to live in. Okay? Now you have to consider how are you going to pay for the taxes and the insurance and maintenance on the house, so you have to figure out how well that's going to work with the rest of the money, but maybe you buy a small condominium and you put some money aside. So you have all of these different possibilities when you get this lump sum, not just a special needs trust. And what happens, bless you, and what happens is that a lot of attorneys who don't do a lot of this work, it becomes a knee-jerk reaction. Oh, we got to put the money in a special needs trust, and the favorite sort of anecdotal remarks among elder law attorneys who do special needs trust is that you get this call on a Friday afternoon at 4 o'clock by a personal injury lawyer, and he says, I just settled this multi-million-dollar case, and I need one of those special needs trust thingies. Could you just put something together for me for Monday? And the answer is that, of course, I'm going to now email you my 20-page questionnaire, and as soon as I get it back from you, I'll be happy to do one of those thingies for you. And so basically, they say, well, what do you mean 20 pages? I say, well, I need to know the answers to all these questions before I analyze it and figure out what the best thing is, But unfortunately, that's the personal injury attorney who knows better than we do how to get $1 million from an insurance company. I wouldn't know how to do that. I would ask, but they probably would say no. But they know how to do that. What they don't know is after they get the money, how to keep the person on public benefits. So basically, this becomes a sort of contentious relationship, which is why, just anecdotally, I will say also that I enjoy the elder law part of my practice better than the special needs trust part, because dealing with trial lawyers can sometimes be a learning experience, for both of us. But it's just something to remember that you're going to be dealing in practice, when you go in practice, with attorneys who don't appreciate the knowledge that you have in this area. And they think it's just, again, taking something out of a form book. And as you've already discovered in a short period of time, there's more to it than just the form book. So we talked about the D4A trust in terms of being irrevocable, used for the sole benefit of the disabled person, and the Medicaid payback, okay? Also, the other characteristics are that the funds are the funds of the disabled person. It's not the parent's funds. We're going to talk about that. It could be if the parent wrote a will without a special needs trust, and now the child is going to inherit, $1 million, and he's disabled, then once he inherits it, it could be his trust. And that's another topic I'll try to remember to get to a little bit later, and that's reforming trust. But basically, we're talking about money that belongs to the disabled party, so like I said, it may come from inheritance, divorce, or a personal injury settlement. The other important characteristic to know is that the purpose of a special needs trust, at least theoretically, is to supplement the public benefits and not supplant them. Meaning, if you start using the money in a special needs trust for food or shelter, you're going to lose some of your public benefits. And there are SSI rules that have to do with that. But fortunately, you won't necessarily, you could potentially lose all of them depending on what you do with the money. But that's the administration, and again, we'll talk about that a little bit later. The last characteristic that's really comes first is that the first party special needs trust, with the D4A trust, has to be established, and that's the key word, the terminology has to be established by a parent, a grandparent, the guardian, or the court. So for instance, if a disabled individual receives, let's say, an injury settlement of $100,000, and after analysis we decide that a special needs trust is appropriate, the first thing I have to look at is does that individual have a living parent or grandparent who can be the grantor to establish the trust. If he does, well, then that's fine. If he doesn't, but there's a guardianship, then we can petition the court and the guardian will establish the trust. Or sometimes, if there is no guardian and no parent and no grandparent, then we have to either establish a guardianship or do like a freestanding action where you really don't want a guardianship established because you don't really need it. And the reason you don't need it is because you have a disabled individual, but it's a physical disability, it's not a mental one, so there's really no need for a guardianship. He can handle things himself. He lives maybe in a group home or something, but he is clearly disabled. But you have to have either a guardian or the court to establish it. So in this case, when you do an independent action, you're asking the judge, in effect, to sign the trust, and that's the court. And from what I've heard around the state, some judges will sign the trust, but some may not. And in that case, you have a problem. So you're going to have to establish a guardianship, even if you may terminate it, right afterwards. But it really depends on your court. So that's basically the self-settled or the D4A trust. Those are the characteristics. Those are the examples of what it's usually used for. And again, when an attorney comes before you, if you're working in the court system, you may ask a few questions like, have you analyzed the case to see if this was the best way to go in this case? Was it better to buy maybe exempt assets? Obviously if it's a $5 million settlement, you're not going to be buying exempt assets. But a smaller case, you might spend the money down by buying like a house or a wheelchair van or some exempt asset, funeral arrangements, something rather than do a trust. Because remember, when you have a special needs trust, a D4A trust, you're going to have a trustee. And normally the trustee will be an institution, it'll be a bank. And they charge money, real money, so that basically, in addition to paying the attorney to do the trust and go to court, you also have the expense of administration. So of course, when the person's in front of you already, you already had the expense of the attorney drafting the pleadings and doing the trust. So in a way, it's a little bit too late to say, your client could save a lot of money here. And of course, the attorney doesn't want to hear that because he's the one who's getting paid, at least part of the fee, not the administration, but initially setting up the trust. So essentially, you're at a disadvantage in this context by being in the court system because you're seeing it after the fact. But when you get out in private practice, remember that you can sort of catch these things in the beginning so that you can determine what is the best thing for the client. All right, so that's the D4A trust. The next type of special needs trust you're going to see is going to be, and I won't give you the beginning of the U.S. code because it's the same as I've given you, but it ends in D4B, capital B. And basically, the D4B trust is what's called a qualified income trust or an income cap trust. And let me explain to you what that's all about. Essentially, a certain number of states are called income cap states. And I think the other states are called 209B, which I think comes out of the Social Security regulations. I don't really worry that much about it because Florida is an income cap state. And what that means is if you're applying for Medicaid, there are certain income limits. And if you're $1 over the limit because your Social Security and a pension puts you even $1 over the limit, categorically you do not qualify for Medicaid. So in 1993, when all of these lettered trusts that I'm mentioning, the D4A and now the D4B trust, came into existence in what's called OBRA 93, which is the Omnibus and Reconciliation Act of 1993, that created these trusts. Congress basically were trying to solve different problems with these different trusts. And with the D4B trust, what they were trying to do was to say, if you're $1 over the limit, but you create this qualified income trust, we will allow you to put the excess income in that trust every month. And by doing that, if let's say you're over the limit by $100, and you put, say, just to be safe, $300 a month of the person's income in the trust, then what you're doing in effect is you're lowering their income for purposes of Medicaid, counting their income to see whether they're over or not. So by doing this, you now qualify for Medicaid because you've kept your income below the income cap limit, okay? So that was the purpose of this trust. Now this trust has to be irrevocable, and again, it can be established. It's typically established by the trustee and the grantor. The grantor being the person, let's say, who's going into a nursing home or needs this type of trust to qualify for Medicaid. But again, there may not be a power of attorney, because if there is a power of attorney, that person who has the attorney in fact can sign the trust for the disabled person, and then the trustee can sign the trust as well. But if you don't have a power of attorney and the disabled person is disabled to the extent that they're just not competent to sign a trust, again, you're back in court trying to get the judge or set up a guardianship to sign that trust. Medicaid creates a fiction, and they will allow a spouse to sign the trust without going to court. But in many cases, there is no spouse. They used to create another fiction, which they now do not do, which they used to say that you could sign it and put like John Jones at the direction of Mary Smith. And they sort of let you create that fiction. That seems to be gone all of a sudden. So basically, you could wind up in court, and that's why you will see these trusts from time to time where there are no assets, but the income is over the limit. And so as a result of that, to get the income below the limit, you need this type of trust. Some other characteristics of the trust is that there is a Medicaid payback, again, in this trust, but you don't really care that much because the trust is solely for income. So you're not going to have a person's assets. So Medicaid, when the person dies, will be lucky if they receive $100 out of it, because the money goes in and then goes right back out that same month, usually to a nursing home. So there's never any real accumulation of funds. It's Congress trying to solve a problem, and you might ask yourself, if the problem is that if you're $1 over the limit, you don't get Medicaid, but if you establish this trust and put the income in, then you do get Medicaid, what's the point? And we, when I was chair of the elder law section of the Florida Bar, one of the things we did, and we've done it a couple of times, is try to go to DCF and try to get them to just get rid of this requirement, but they say, no, it's federal, we can't do it, we're not interested in doing it. And I think in their mind they figure they're going to catch somebody. Somebody will apply for Medicaid, not realize their income's over the limit. They won't get Medicaid for 3 or 4 months because the trust has to be in place and money has to go in and go out in the month you want Medicaid. So if somebody discovers in March they needed an income trust in January, they're out of luck. They can now establish it and they'll be okay for the month of March, but you can't go retroactive with one of these trusts. And when you apply for Medicaid, in addition to furnishing the trust, you have to furnish a bank statement showing the money going in. So even if you had some person who backdated a trust, it wouldn't be an attorney, it'd be most likely one of these Medicaid planners that has no license, so they have nothing to lose. They would do something like this, but they wouldn't get very far because they would still need to produce a bank statement. And how could they produce a bank statement for January if they didn't have the account established? So basically, you have to recognize when a client comes into your office, if you're doing any kind of Medicaid work, that their income has to be over the limit. And also what you should know is Medicaid works on gross and not net. So they may show you their bank statement and their pension and Social Security is, let's say, under the limit by $100, and you say, oh, this is great, I don't need a trust. But if you ask them to bring in their Social Security statement, you would see the gross Social Security is more than the net. And that's because Social Security deducts for Part B Medicare, which is usually $104 a month. They could also be deducting for a drug plan, which might be $15 or $30 a month. Also with a pension, it's even worse, because until you see the statement from the pension company, they could be deducting for withholding tax, health insurance, dental insurance, I've seen life insurance. So Medicaid looks at the gross number, and if you get the two statements and you look at the gross number, you could easily be over the limit while the net number is under. So this happens with nursing homes all the time, because the staff there is usually not trained and there's a big turnover, and so they ask people to bring in their bank statements and they analyze the case based on bank statements, and that's a big mistake. So we don't make, in fact, in many cases in my office, I create these D4B trust, or the qualified income trust, in cases that I'm not sure. And I tell the client, let's put in the trust, let's fund it this month with $500. If it turns out, when we finally figure out what the income is later on, that we don't need it, so you just stop using it. But you can't, you can always do that, you just can't go back and now create it in the month, you know, you don't have it. So those are some of the little kind of tips on qualified income trusts and how they work. It's going to get a little bit confusing and murky when we talk about the next trust, because there's a little bit of an overlap here. And that next trust is what you're probably familiar with. You've probably seen this, and that's what's called a pooled trust. That's P-O-O-L-E-D, pooled trust. And that's actually a D4C trust. So we've talked about the D4A, we've talked about the D4B, and now we're going to talk about the D4C trust, which is a pooled trust. And what a pooled trust is, it's basically one of those special needs trusts created by OBRA 93, and it was set up basically to be established very similar to a D4A trust, but this is established by a nonprofit. And so the trust will be in existence already. You don't have to create this trust. What you do to become part of this trust is you fill out and execute what's called a joinder agreement. And the joinder agreement makes you a part of this trust, excuse me, and then when you do this joinder agreement and you send in your money to the pool trust, your money is pooled, meaning it's invested with other people, but it's accounted for separately. So in other words, if you send in $100,000 to a pool trust, they know that $100,000 is your money, and they give you choices of how to invest it. So if you want to be safe, you'll just put it in a money market account, although since money market accounts are almost yielding negative returns these days, it almost breaks a buck, as they say. There are other types of short interest types of funds that pool trusts are now using, which will pay maybe 1 or 2%, but it's pretty safe. And so some of the money may be in that type of a fund. If you're going to not need a lot of the money for years to come, then you may invest it in more of an equity type of fund for growth. But basically, the trustee, is going to be the people that have set up the pool trust, so you don't have to look for a trustee, it already comes with it. They charge fees which vary from pool trust to pool trust. One pool trust, for example, just to give you a little bit of a flavor, charges a $500 setup fee and then 3% of your assets that you put in the pool trust, and each year they charge 3% of what's ever left, and that's how their fee is. Now, a couple interesting things about a D4C or a pool trust. Unlike a D4A trust, where if Medicaid has given out money that you have to pay Medicaid back, the pool trust has a choice. So let's say you have a case where the Medicaid has paid out $100,000, and when the disabled person dies, there's $50,000 left in the trust. Normally, if it's a D4A trust, that money has to go to Medicaid. But with a pool trust, they have a choice. You can either pay back Medicaid, because the family will never see the money now, or the pool trust can retain the money. And if they retain it, they will use it for other people in the pool trust who are disabled, who maybe have run out of money, but are still in need of services, or maybe a wheelchair van or a wheelchair or something, so that at least you know that while your family may not get the money, it'll at least go, to a good cause. So that kind of makes it a little bit different. If there's money left over after Medicaid's been paid back, then again it will go to the family. But the pool trust normally retains maybe 5%. But that's normally negotiated up front with a pool trust. One of the interesting characteristics of a pooled trust, and here's where I talked about this overlap, is you can actually use a pooled trust as a substitute for a qualified income trust. In other words, you might say, well, why would you do that? Well, if you have somebody that only has income that's over the limit, you wouldn't do that. You would just use a qualified income trust. But supposing your client has $20,000, which you really would like to retain. Yeah, maybe you could spend it down, but it would be foolishly just to get rid of it. Maybe you'd like to keep it so that even though the person will be on Medicaid and they might even be in a nursing home, you may still want to use it for extra things that the person needs, supplement their care. But they also have income over the limit. So what you can do is you can use a pool trust, and the pool trust will hold that $20,000 so that it will be protected and you can use it. But at the same time, they can also take in the income every month, which they will take 3% of the income. But it may only be $50, $60 worth a month. But they will then you'll be able to use that as an income trust. So it's kind of interesting where you can sometimes use a pool trust to take care of both. There's another characteristic of a D4A trust that I didn't mention, and also it affects the D4C trust. And I didn't want to mention at the beginning because I wanted to wait till I got to the D4C trust. But basically, the characteristic is for a person to do a D4A trust, a self-settled special needs trust, they have to be under 65 years of age. If they're over 65, they cannot use a D4A trust. Interestingly enough, in the last few years, CMS in Washington, which is the Center for Medicare and Medicaid, decided that whoever drafted the provisions in OBRA 93, and we know where the provisions came from, they actually were dictated at 11 o'clock at night by an elder law attorney who was literally woken up in the middle of the night and said, we're about to pass this bill and we want to try this idea of yours and we want to get these provisions in it at the last minute. Could you please dictate it to us? And he literally in the middle of the night was dictating over the phone. And so it didn't exactly come out perfect. And so what happened was, this is not unusual in making legislation, is like, as they say, it's like making sausage. So basically, what they were allowing were people who were over 65 to be able to participate in the D4C trust or the pool trust, even though they couldn't participate because it's very clear in the D4A, it clearly says you have to be under 65. Well, finally, 20 years later, CMS decided, we don't think they got this right. So we're going to say that we don't think that and Social Security, I think, came out with this first, that we don't think that if you're over 65, you should use a D4C trust. So basically, if you're anywhere in the country and you're applying for Medicaid and you're over 65, or applying for SSI, you can't use a D4A trust or a D4C. But if you're applying for Medicaid through the state, meaning you're not going to Social Security, in some states you can still use a D4C trust, and Florida, thank goodness, is one of them, but in other regions of the country they've said no, and there's been federal litigation on this, and it's gone in both directions. What we need is Congress to basically fix this by legislation, and National Academy of Elder Law Attorneys, is moving in that direction, trying to get something done, and hopefully that will be clarified, because it's ridiculous that in one part of the country you can use a federal statute and in another part you can't. It doesn't really make any sense. So, but that's important for you to realize that at least now in Florida we can use it, but the over 65 rule applies to D4A trusts for sure. So if your client is over 65, you can't use it. I actually had a test question. It was a long essay when I took the Certified Elder Law exam, the national one, the SELA it's called, and the essay was very clever because it didn't say the person's age, it just gave their date of birth. And they first showed in the essay that they had set up a special needs trust, and the person was under 65, but then later on they had another accident and they got money, which I had to realize is they were now over 65, so they couldn't contribute that additional money to that trust. They had to buy a house or do something else. And they did it in a way that a lot of people missed it because they didn't come out and just say he was 67. They just gave his date of birth, and you had to start counting on your fingers to see how old the person was. So you got to be careful of that because it's a knee-jerk reaction to set up these trusts, but if the person is over 65, you may have to use a pool trust or do something else, okay? So, so that's the pool trust. All right, now we're going to talk about a couple other types of special needs trusts that are very important, and you're going to see these. The first one is called a third-party special needs trust. This is the one that you might be used to seeing a lot of here, and that is where the money did not belong to the disabled person. The money belonged usually to the parent or a grandparent, and they want to leave it to that part of their estate to that disabled child, but they don't want to cut off public benefits. Perhaps the child's already on Medicaid, or they think they'll eventually be on Medicaid, and they don't want to ruin it by giving them the money and now they don't qualify. Also, that child would then have to put the money in a D4A trust, assuming they're under 65, and as we talked about, it's subject to a Medicaid payback. So that would really be, could be a disaster. So what the parent does, if they go to a lawyer who knows something about special needs trusts, and most attorneys today at least know about it, if they don't draft it, at least they're aware of it, they will create a special needs trust in their will or in their revocable trust. And the magic language that you have to put in there, and I say magic language because it's really what it is you have to put in there that the funds are to supplement public benefits and not supplant them. And there was a famous Ohio case before these statutes, came into effect years ago. And Ohio is very litigious in terms of public benefits. All of their Medicaid planning is by litigation, literally. And what happened in that case is the government wanted to throw out the third-party special needs trust by saying this money should be considered an asset of a disabled person. And when the judge read the will, he saw that 9 times in that provision it said to supplement public benefits and not supplant them. So when the judge ruled in favor of the beneficiary and against the government, he put in his decision, the lawyer who drafted this trust put in a provision that said it is clear that we want to supplement public benefits and not supplant them 9 times. So he must have meant it. And that was the language in that decision, and so they ruled in favor. So when we draft special needs trust, I don't know if I have it in there 9 times, but you'll see it in there a couple of times. And it's pretty clear, but yet the regulations are very clear under the Medicaid rules in Florida, so the way I draft it complies perfectly with what they want, and they're not as litigious here as they were in Ohio in those days. So basically, again, the characteristic of the third-party special needs trust is it's the funds of a third party. It's the parent's funds, not the child's funds. And the trust is not subject to Medicaid payback. That's the important part. So you can write the trust and say, while my child, John, is alive, I want the funds to be used to supplement that child's benefits and not supplant public benefits. But upon his death, what's ever left will go to my other 2 children. It will not go to the state to pay them back. But if a lawyer doesn't understand that the special needs trust is required because they don't bother to ask the client, this should be on your intake sheet when you're doing estate planning, right up somewhere on top, do you have a beneficiary that's going to receive something under this will that is disabled or on public benefits? Because that's where you need to be cautious. Now, granted, you're going to do wills for clients where later on a child becomes disabled and he wasn't disabled at the time and you didn't know about it. That's not going to be malpractice on your part because you're not responsible to follow people around for the rest of their life. But you might want to tell that client if in the future, God forbid, but one of your beneficiaries becomes disabled or on public benefits, you need to come back and see me because we need to amend that trust and or just rewrite it and put in a special needs trust for that child. Some parents in the past, and some still do, rather than go to a lawyer and do the right thing, they'll say, well, I'll leave the money to my other 2 children, not the disabled child, because my other 2 children are real good kids, and they're going to help that child. That's a very dangerous thing to do. Even if those other children feel that way today, they could die in the future, and the money goes to their children. They could get divorced, and they lose it to the spouse. So it's always better practice to do a third-party special needs trust so that child, is protected. All right. The other type of trust, which is very much similar to a third-party special needs trust, and actually it is, but it's called something different, is what's called a qualifying special needs trust. Now, The qualifying special needs trust came out of the elective share statute. I don't think any of you were probably in law school in 2001, which is like, or not, or when I think it came into the statute. But basically, for years, when spouses wanted to disinherit a spouse, which was usually like a second marriage situation, they couldn't write a will because the elective share was 30% of your estate. So they would set up a revocable trust, put the assets in a revocable trust, and name their kids a beneficiary. Well, if you went back and you read the old law, the old elective share statute said that the elective share was 30% of the assets subject to administration. Well, we all know a revocable trust is not subject to administration. So that's how they got around it. And I think it was a famous case. I think it was called the Friedman case, or Freiberg, I think it was. It was in the third DCA too, which is interesting. At any rate, the real property, probate, and trust law section of the bar decided that they needed to fix this. So I think they fixed it in about 30 pages worth of the statute. But they created this, this very large statute now, which is the elective share statute, which if you studied it in law school or you just know about it because you're in this venue here, you know that the elective share is a lot more than what's subject to administration. Well, of course, the problem is that under the Medicaid rules, if you have a spouse, let's say in a nursing home, and you know you don't want to leave the assets to that spouse because they're on Medicaid. You die first and you're at home, and the assets go to that spouse, they're going to lose their Medicaid. So you want to leave it to your children. The problem now would be that that spouse has an elective share, assuming you don't have a prenuptial agreement. So if you have an elective share, under the Medicaid rules, if you say, well, I'm just not going to take my elective share, we're not going to file for it, it's considered a transfer of assets. To the extent of what you didn't take goes to the kids. Now, it's considered a transfer of assets, and that will disqualify you from Medicaid. Could even be up to 5 years, depending on the amount of money. And so when this statute for the elective share was rewritten and drafted, the elder law section had input, and we created in that statute something called a qualifying special needs trust. So essentially, what you can do is you can either leave everything to your spouse in a qualifying special needs trust, or a minimum of 30%. And sometimes you decide to leave 30% because you want to leave the 70% outright to the children. You don't want them to have to wait till your spouse, passes, because it might be years from now and those children can use the money now. But sometimes you feel you want the money in a trust until both parents, are dead. So you do 100% or you do 30%. And what happens is that, and there's a whole procedure, we're not going to get into it because you can read it's all outlined in the statute, but essentially in the probate process, you fund the special needs trust. You then, when you finish with probate, you contact the Department of Children and Families, you send them the will, you send them the bank statement, you explain how you funded the special needs trust, and they just, they see there's a change of circumstances, but your client continues on Medicaid because the money is now in the same as like we talked about. It's like a third-party special needs trust, so the money's there, and let's say if the children, or whoever the trustee is, let's say it could be the children, they're able to use that money to supplement the benefits of that parent, okay, that's in the nursing home, but it will not interfere with their Medicaid, and upon their death, again, there's no Medicaid payback, so the money will go to the children. So a qualifying special needs trust is a must when you have a husband and wife situation and one is on Medicaid in a nursing home and one is at home, because you presume the one in the nursing home will die first, but I've probated several estates, and I have a couple of them right now, which it didn't happen that way. And nobody can guess because you're dealing usually with two elderly people. No one's going to take the guess who's going to die first. So you draft the will with a qualifying special needs trust. Another important characteristic of this to be aware of is under federal law, you cannot create a special needs trust for a spouse other than by will. So you cannot do a revocable trust and put a special needs trust in it for a spouse. You can do it for a child, but not for a spouse. So one of the drafting techniques we use is if a client insists on having a revocable trust, or we think it's just a much better idea, because the assets are in the well spouse's name. They had to have been transferred before we got the other spouse on Medicaid because they couldn't have more than $2,000. So everything is in the well spouse's name. And if they want a revocable trust, the way it's done is you transfer the assets to the revocable trust, but when you draft the revocable trust, you draft it with what's called a reverse pourback. You're familiar with pour over wills. This is now a reverse pourback. What the trust says now is if the grantor dies before the spouse in the nursing home, 30% of the assets in that trust are poured back into the estate. So they go into probate. And then the will creates that special needs trust. You see? It's a little convoluted, but that's how you get your cake and eat it too. Because the rest of the trust will say that if the spouse in the nursing home predeceased, so you don't have to do that reverse pourback, now it goes to the children either outright or in some sort of trust you set up in that revocable trust, depending on what you want to draft. So you can either do it that way, or you can just write a will, and then everything goes into probate, and the will creates the special needs trust, you know, and then you don't have a revocable trust. But some clients want a revocable trust, so you draft it that way. All right, so those are the different types of trust. With regard to trust administration, kind of very briefly, it's very important when you do a special needs trust who you pick as trustee, because an attorney can go through painstaking effort analyzing the case, deciding what they want to do, and then drafting the trust and funding it, and they do a perfect job. And then they turn it over to a family member to act as trustee, and they explain to the family member the do's and don'ts. They even give them some literature. And what does a family member do? They go right out, and when the beneficiary says, you know, I'm going to Disney World, I could use like $800, they write him a check for $800. If that child's on SSI, if you pay cash to that child out of the trust, he loses his SSI dollar for dollar. So if his SSI is $796 and he gets $800 that month, not only does he lose his SSI, which means he literally got nothing, he lost the $800 because the government is going to take it away, so the net gain is zero, but also he lost his health insurance for that month. So if he needed health insurance that month, he just lost it. So a professional trustee, you know, like a Sun Trust or any of these larger trustees that specialize in special needs trust, they know these rules, and they will make sure that even if a family member says, you know, my son's going to Disney World, could you send him $800? They'll explain to them why they're not going to do that. You know, they'll say they'll put it on a credit card or charge it. You know, they'll do something else. And also, if they say, you know, my son needs something to help pay his rent this month, they know that under the 1/3 reduction rule, he may lose a large part of his SSI that month. The rule is if you get $1 of SSI, you get Medicaid for the whole month. So, you know, that's your Medicaid, but you can still lose most of your SSI. So you want a trustee who knows what these rules are, because you could get the entire trust disqualified, or you could lose public benefits by having the wrong trustee. So I'm telling you this for two reasons. One is obviously when you go out and practice, you'll know something. But the second reason is while you're sitting here and you're looking at somebody's pleadings and you see that they got their brother-in-law is going to be trustee, you might say, does your brother-in-law, does he have the skills to do this? Who are you going to be staying on as his advisor? And the attorney may say, well, you know, I'm just a probate lawyer. I don't really do public benefits. I just got these forms from, you know, one of the attorneys. And so, well, you could really have a problem here, you know, and it may not be a good idea. And maybe a judge will pick it up, maybe a judge won't pick it up. So you might want to look at who these trustees are, and especially if there's a lot of money involved. Because if you got a trust like that disqualified, you know, you could have really a big problem. So, and one last comment I'm going to make is that, unfortunately, when a person dies and there's a special needs trust, now we're going back to the D4A, not the third party, where you have to pay back Medicaid, and let's say the person hasn't made funeral arrangements. You might think that, well, I'm sure Social Security will let me take, you know, $8,000 out of this and make funeral arrangements because we have to bury the poor person, but they don't, okay? And basically, if you made the funeral arrangements before the person died, that would be a legitimate expense and you wouldn't be a problem. But if you don't, they're going to tell you you can't. and you got a real problem. So as unfair as that sounds, that's the law. So about the only expenses I think they will allow you would be, like the state will allow you, like administration expenses to close up the trust, you know, and that sort of thing. So again, you might, and here's where it comes back to what you do now, you're sitting with an attorney and say, look, you know, when you fund this special needs trust, you might want to consider some expenses that you know the person's going to need down the road, like funeral expenses, and you may want to do this right away before the person dies, and then the money is all going to go back to Medicaid. So again, this goes into the administration, and a good trustee, when they're appointed and they take over and they open it up on the books and they get to see who the beneficiary is and talk to them or talk to the family and look at the money, will make these types of suggestions because they know what's going to happen if they don't. So that's a little bit about the administration of trust.